SwayamPrabha. Digital India. Educated India.
Good day everyone, and a warm welcome to all our viewers. I am delighted to have you join us for this engaging and enlightening journey into the world of jurisprudence. I am Dr. Simranjeet Kaur, Professor and Principal, School of Law, CT University, Ludhiana. In today's lecture, we will discuss the legal formalism and rule skepticism. So let's embark on this intellectual journey together and uncover the fascinating world of legal theory. So let's start with the topic. So let's first discuss what legal formalism means. Legal formalism refers to an approach to the jurisprudence that emphasizes the discovery of the legal principles through logical analysis and the application of those principles to the facts of a case. Formalist believes that by applying a consistent set of legal rules to a given case, sound legal decisions will be the outcome of the logical deduction. Legal formalism can be understood as both a descriptive theory of the law and as a descriptive theory of the law. Legal formalism seeks to discover uncontroversial principles of the common law and apply them to the facts at hand. Legal formalism differs from legal realism as it does not consider the social interests and public policy. Ramifications of the rulings. In this respect, legal formalism is an attempt at creating a rational and scientific legal system, absent of political considerations. As a prescriptive theory of the law, proponents of the legal formalism argue that legal formalism is a necessity to maintain the separation of powers by limiting the judges to educating what the law currently is, rather on what the law ought to be. Legal formalism prevent the encroachment of the judicial powers into the power of the legislative and executive branches. Critiques of the legal formalisms argue that this approach is ill-suited to resolve injustice or promote fundamental rights. Legal formalism was the dominant theory of the legal thought in the United States from 1870s until the 1920s, when it was replaced by the legal realism. However, vestiges of the legal formalism can be found throughout the legal system. For example, textualism and originalism are both formalistic approaches to statutory interpretation used in the constitutional law. The era of the legal formalism is usually taken to refer to a period in American legal thought between the 1860s and 1920s, when a new generation of post-bellum treaties, writers and the legal academics sought to discover the underlying principles of the common law cases and put them into a rational order. This period is sometimes also referred to as the era of the classical legal thought, a phrase which takes it not only the perceived methodology of the jurist, but a broader Weltanschauung shared by the judiciary, which favored laissez-faire and individualism. In contemporary jurisprudence, the term formalism refers to specific approach to adjudication and constitutional interpretation, which has its defenders as well as its critiques. However, in the era under the studies, it was neither termed which jurists used to describe themselves nor one which their critics used to describe them. Formalism was in many ways defined by the anti-formalist critiques of the later generation of the realist thinkers. In the view of the realist, formalist treated law as a system of the abstract concepts which could be applied by the deduction to the facts of many particular cases. They are blind to the policy choices and social purposes which had shaped the content of the law. They saw law as an adjudicative system in which judges neutrally resolve the disputes between autonomous individuals rather than one in which legislation played a critical role, and consequently they privileged private law and marginalized public law. It generated in Roscoe Pound's famed critique a mechanical form of jurisprudence in which rules and doctrines were judged by their conformity to a supposed science and not by the result to which they led. Recent scholarship has questioned this image of the legal thinkers of Gilded Age. The range of the opinions within orthodox legal thought in this era has been shown to have been rather larger than realistic caricature suggested, with many jurists developing theories in which moral reasoning and historical investigation played major roles, as shall be seen in what follows. The formalist jurists were not simply narrow logicians who had embedded the learning of analytical jurisprudence. They were scholars bred in the common law tradition, who sought to make sense of it for a new age by incorporating the method of the latest jurisprudence learning, both historical and analytical. Formalism and realism defined. The term legal formalism and legal realism have a strong, long history in the legal thought. Over the years, they have accreted so many meanings and valiances that each has become an all-purpose term, both of approbation and of disapprobation, surpassing in this respect even judicial self-restraint and judicial activism. Formalist can mean narrow conservative, hypocritical, resistant to change, chaotic, descriptive, inaccurate, that is, unrealistic in the ordinary language sense of the word. Ivory-towered, fallacious, shallow, authoritarian, but also rigorous, modest, reasoned, faithful, self-denying, restrained. Realist can mean cynical, radicalist, manipulative, hostile to law, political, left-wing, knave, but also progressive. Humane, candid, mature, clear-eyed. These uses reflect the polemical character of so much writings about the law. Legal realism is also used to refer to the work of political academic lawyers, mainly on the Yale and Columbia faculties during the 1920s and 1930s, and to specific and diverse ideas held by those men. Legal formalism refers to the work of judges and academic lawyers who the legal realists attack and who attacked the realists in the turn. Formalism, realism, and the common law. The common law, which I use broadly to mean all the legitimately judge-made law, is a collection of the concept such as negligence, consideration, possession, good faith, conspiracy, impossibility, and laches. These concepts furnish major premises for the decisions of the cases. The minor premises are the facts of the cases. The model is all men are mortal. Socrates is a man, therefore Socrates is mortal. The major premise is the concept or the definition. The minor premise is factual statement. So, if an enforceable contract is a promise supported by the consideration and A's promise to B was supported by the consideration, the promise is a contract. Of course, the syllogistic structure of a real case is more complicated because of defenses, exceptions, and etc. But that no more affects my analysis than does the fact that some mathematical problems are harder than others. Obviously, the choice of premises is critical, and that is where public policies come in. Why enforce only promises supported by the consideration or only promises that are consciously accepted? The reason, if it is a good reason, has to be traceable in some notion of policy rather than just be the result of arbitrary personal preferences or antipathies or class bias or some other thoroughly discredited ground of judicial action. It cannot be logic. Logic is used to grow from premises to the conclusion, not to obtain the premises. Of course, a premises may be the result of deduction from some more basic premises, but eventually one is forced back to a premises that cannot be obtained or proved by deduction. The 19th century formalists sometime overlooked or perhaps deliberately concealed this point. Since the correct choice of the premises on the ground of policy is more uncertain than the correct deduction of the conclusion from its premises, the formalists prefer to focus on the process of deduction rather than on the choices of the premises. They like to give the impression that the premises were self-evident, meanwhile packing as much into the major premises as possible. To shorten the choices of deduction, the result is Platonism, the idea that concepts exist out there like trees or rocks rather than are created. Thus, Langell said that a person who returns a lost article for which the owner has offered a reward has no contractual right to the reward if he did not know about the offer, because then the act of the return could not have been, and without such acceptance there cannot be any contract. But in so reasoning, Langell was treating the concept of contract as if it were a thing which could not be altered without becoming something different. If you take the legs of a table permanently, not just for the storage or moving, it is no longer a table. But it does not follow that if you do not have an acceptance, you do not have a contract. A contract is just a promise that courts will enforce, and if there is a good policy reason for doing so, they can decide to enforce a promise even though it was not consciously accepted. Nor is it a good reply that a contract without acceptance is like a table missing only one leg. That not essential. Defining characteristics of the concept of contract is missing, as would be the case if there were neither offer nor acceptance. What should count as essential? Defining characteristics of the contract is not a semantic question. It is a policy question. We may enforce any promise we want and call it a contract, just as we can punish a drug dealer for his agent's possession of illegal drugs by saying that the dealer has constructive possession. In the reward case, the question for the court should be, putting aside the issue of adherence to the precedent, ought the unconscious acceptance be deemed to create a contract? I would think the answer should depend on whether, if it is more, lost articles will be returned at an acceptance cost to the legal system. This happens to be a difficult question. The problem was not that Langdell was a bad formalist in the sense of making errors of the logic, but that he was uncritical about his promises. Another example from his time was the generalizing of the rule of capture for the wild animals. The rule that a wild animal such as a rabbit is not owned until you catch it into a concept that ownership of natural resources without a fixed locus is governed by the rule of capture, and then deducing from the concept that rights in the fish, valuable for bearing animals, and oil and gas ought to be governed by the rule too. Conscious acceptance of the offer. The nature of the textual interpretation, decoding communication. The major premises of the syllogism is a definition like all men are mortal, or what is the same thing, a rule, a perfect tender rule, or what is again the same thing, a concept that's negligence, which is stated as the rule of the definition is all persons are prima facie liable for the accidents resulting from their failure to take due care. That's the cost justified level of care. The common law, like the system of the real numbers, is a conceptual system, not a textual one. The concepts of the negligence, of consideration, of reliance are not tied to a particular verbal formulation, but can be restated in whatever words seem clearest in the light of current linguistic conventions. Common law is thus unwritten law. In a profound sense, there are more or less influential statements of every doctrine, but none is authoritative in the sense that the decision of the new case must be tied to the statement rather than to the concept of which the statement is one of an indefinite number of possible formulations. Considering the importance that the common law attaches to the decision in accordance with the precedent, it may seem odd to divorce statutory and constitutional law differs fundamentally from the common law in that every statutory and constitutional text the starting point for the decision, and in that respect, but that respect only corresponding to judicial opinions in the common law decisions. Making is in some important sense not to be revised by the judges. They cannot be treat the statute as stab at formulating a concept which they are free to rewrite in their own words. This might seem to entail just that formalist reasoning in statutory or constitutional law would be deduction from a text and therefore would be possible as long as the text was as precise as a common law concept. But there is no such thing as deduction from a text. No matter how clear the text seems, it must be interpreted, or decoded like any other communication, and the interpretation is neither logical deduction nor policy analysis. The terms formalism and realism, as I have defined them, thus have no application to the statutory or constitutional law, except, as I have said, when the framers' command is simply that the judges go out and make common law, a conclusions obtained by deduction is already contained in the premises, in the sense that only materials used to obtain the conclusions are the premises themselves and the rules of the logic, but meanings cannot be extracted from a text merely by taking the language of a text and applying the rules of the logic to it. All sorts of linguistic and cultural tools must be brought to bear and over the simplest text to get meaning out of it. This is not to suggest that all the texts are ambiguous. A text is clear if all or most persons having the linguistic and cultural competence assumed by the authors of the text would agree on its meaning. Most texts are clear in this sense, which is the only sense that captures the meaning of the word, clear as applied to the text. Some other approaches to the interpretations of the legislations. Before defending and then illustrating my approach, let me contrast it briefly with some others. One that is particularly interesting in the light of my desire to banish talk of the formalism and realism from the interpretive domain is that of Hart and Sachs, which is broadly similar to my approach, but differs crucially in the reckoning that courts deem the enacting legislators reasonable persons intending reasonable results in the public interest. If there is a permissible assumption and if there is a broad agreement on what is reasonable and public interested, the interpretive problem disappears. Interpretations disappears. All the statutes become pellucid and unequivocal, directives to the courts to achieve sound results. A court complies with these directives by creating the concept like concreted activities under the National Labour Relations Act or public convenience and necessity under the Common Career and Public Utility Statutes, which the court then proceed to apply formalistically, maybe after deducting sub-concept from them to particular cases. Suppose, though this was not Hart and Sachs' view, nor is it mine, then all the legislatures are reasonable in the special sense of wanting to maximize the society's wealth. Then they would want the court to interpret their every statute to make it conduce to the end. The same formal analysis used to explain and for those accepting its substantive promises to justify common law decisions could be used to explain and justify statutory decisions. In fact, the statutes would be precedents, that is, tentative formulations of the legal concepts. The court would be free to revise the formulations. Unfortunately, neither the specific assumptions that the legislator seeks to maximize the society's wealth nor the general assumptions that it seeks to achieve the reasonable result in some consensus sense of reasonableness. For example, one that combined efficiency with the most widely accepted distributive norms, such as that containing racial discrimination, is tenable in the light of intellectual and political developments. Since Hart and Sachs wrote in the middle 1950s and If the second assumptions were tenable, it would not be usable as a guide to applying the statutes. First, the spectrum of the respectable opinion on political and social questions has widened so enormously that even if we could assume that legislatures intended to bring about the reasonable result in all cases, the assumption would not generate specific legal concept to learn what sense of reasonableness the legislature meant the courts to use would require interpretation of legislative text. We cannot escape the interpretation. Second, recent studies of the legislative process stress the importance of interest groups pursuing private goals rather than public interest. In shaping the legislation, there is nothing new in recognition that interest groups are important in the legislative process. But at the time Hart and Sachs wrote it, it was thought that competition of interest groups would achieve a social optimum. The fact that differential ability to organize an effective interest group could well result in serious departures from the optimality was not widely recognized as it is today. The recognition of this danger has made it more difficult to regard statutory text as the equivalent of the President, reflecting the same values and the goals as the judges hold. Many statutes appear to reflect compromises between contending groups pursuing but not avoiding selfish ends. I have exaggerated Hart and Sachs' position in order to make it contrast with mine clearer. Far from thinking interpretation irrelevant, they devote most of their discussions of statutory interpretation to techniques for decoding the statutory communication. It's the only when all else fails that a court is to assume that the legislators were trying to do the same thing that courts do. It's only the most difficult, the indeterminate issues of the statutory interpretation that are to be subjected to the common law, formalist, realist reasoning. The fact that the court is to decode first and reason in the common law fashion only if the effort to decode fails suggests that Hart and Sachs were well aware that not all the legislation is reasonable in the common law sense. Nevertheless, the discussion implies a more comfortable and confident view of interpretation, broadly conceived, than is likely to gain many adherents today. Not only can few today accept the assumptions that the legislative intent typically is to maximize the journal welfare, but there is also greater awareness of the inherent uncertainties of the interpretation. So, I thank you for your time and attention. I look forward to a new session where we will continue to explore the fascinating concept of jurisprudence together. Thank you.